My son built it. You only lived in it, Gloria said, pointing toward the folded flag beside Nathan's photograph. I want the house, the business, and everything else he owned. We had returned from the cemetery less than 2 hours earlier. I still held Nathan's West Point ring, and the scent of funeral lilies clung to my black dress. Gloria had not come alone. Her attorney stood beside her with a leather case and a stack of prepared documents. She claimed Nathan had been too sick to understand his final decisions. Then she accused me of using pain medication exhaustion and 23 years of marriage to take property that belonged to the Whitlock bloodline. My attorney, Evelyn Shaw, pulled me toward the kitchen. Her voice dropped to a frightened whisper. Mara, we have to challenge this immediately. If you let her establish control, she will demand the house and every company account. I looked past her at Nathan's chipped enamel mug beside the sink. 3 weeks before he died, Nathan had held that same mug between trembling hands and taught me, if mother comes for everything, do not stop her too early. At the time, I thought medication had made him speak in riddles. Standing in the kitchen after his funeral, I finally understood that he had been giving me an order. I returned to the living room. Gloria's attorney placed a preliminary claim on the table and asked whether I intended to oppose it. Everyone watched me as though grief had removed my ability to understand English. I touched Nathan's folded flag, then answered quietly, I will review every document through counsel. Gloria smiled because she heard weakness where I had offered procedure. That mistake would follow her all the way into court. I still keep Nathan's olive field notebook in the top drawer of my desk. I do not keep it because of what it protected. I keep it because near the end of his life, my husband used his remaining strength to leave me a path through the people who believed grief had made me defenseless. To understand why I did not fight Gloria that afternoon, we need to return 4 months to when Nathan was still walking through the warehouse every morning and pretending the pain beneath his ribs was temporary. Nathan had retired from the United States Army as a colonel after more than 30 years of service. During his final deployment, he once held an entire logistics convoy overnight because 3 injured soldiers had been left at a damaged checkpoint. His superiors wanted the convoy moving before dawn. Nathan refused until every name was accounted for. After retirement, he founded Whitlock Field Transit in Lexington, Kentucky. The company transported medical equipment, emergency supplies, and specialized personnel across several states. Nathan hired veterans who needed a second career and gave responsibility to people other companies considered too old, too injured, or too complicated. The public saw Nathan cutting ribbons and shaking hands. They rarely saw me correcting payroll errors, at midnight writing hiring procedures, negotiating insurance renewals, or helping him create an apprenticeship fund. Gloria called those things secretarial duties. Nathan called them the reason the company survived its first 5 years. When his cancer returned, I drove him to treatment and worked from hospital waiting rooms. Some mornings he could not button his shirt. Other mornings he insisted on visiting the warehouse because a new veteran employee needed encouragement. He never confused weakness with uselessness, which was one reason Gloria's behavior hurt him so deeply. She began appearing twice a week after learning the cancer had spread. At first, she brought soup and family photographs. Then she started asking where the property deeds were stored, who could sign company checks, and whether the Whitlock name would remain in control if Nathan died before me. Nathan answered patiently until Gloria arrived with a man she described as an estate advisor. The man asked whether I controlled Nathan's medication and whether Nathan feared I would sell the business after his death. Nathan listened for several minutes, then told him to leave our house. That evening, he asked me to retrieve his olive-field notebook from the locked drawer in his study. Inside were handwritten dates, account numbers, and the names of several legal entities I did not recognize. He asked whether I remembered the Whitlock family property outside Versailles. The property was an aging house Gloria often described as the family estate. Nathan explained that years earlier, Gloria had pressured him to use an old company structure to guarantee a real estate project for her nephew. The project failed. The guarantee remained attached to the old house, an outdated corporate entity, and several unresolved tax obligations. Nathan had spent years separating the healthy business from that financial damage. The operating contracts, employees, equipment, and revenue now belonged to a newer structure. A survivor trust protected our home. The veteran apprenticeship fund stood independently. Gloria knew none of that because she had never asked how the company worked after demanding that Nathan preserve appearances. She thinks the name on a document is the same as the value behind it, Nathan said. She also thinks responsibility belongs to whoever she can pressure into carrying it. I asked why he had not confronted her. Nathan closed the notebook. Because she never listens while she believes someone else will absorb the consequences. Over the following weeks, Gloria began telling relatives that Nathan was mentally declining. She said I excluded her from medical appointments and manipulated him into changing his estate. She left messages describing me as a woman who had married into a respected family and intended to leave with everything. Calvin Ross, Nathan's longtime accountant and former Army colleague, quietly confirmed what the notebook contained. The older corporate entity carried a secured loan exceeding $800,000 tax exposure and a civil claim linked to the failed project. The family house Gloria romanticized needed extensive repairs and remained heavily mortgaged. The active business, however, had been reorganized lawfully 3 years earlier. Nathan retained only limited interest in the old structure, while the functioning operation belonged to an employee-centered company with me named as oversight trustee. Our residents had already passed into the survivor trust and would never enter ordinary probate. Nathan did not create the structure to punish Gloria. He created it to protect employees, veteran families, and me from obligations caused by decisions we had not made. The debts remained with the entities that incurred them. He simply stopped allowing Gloria to pretend that ownership arrived without responsibility. During his final week at home, Nathan handed me the brass key from the first workshop we had rented together. Then he gave me a sealed envelope marked "Only open if Mother contests." "There are things worth keeping," he said, "and things worth letting people grab." I placed his West Point ring beside the envelope and asked whether he was certain. Nathan reached for my hand. "Mara, I am not asking you to trick her. I am asking you not to rescue her from a demand she understands only as victory." He died 3 weeks later with my hand beneath his and the olive notebook on the bedside table. After Gloria left our house on the afternoon of the funeral, Evelyn and I opened Nathan's sealed envelope. The first pages summarized the trust, the business reorganization, and the protected accounts. The final memorandum addressed Gloria's expected claim. Nathan had written one sentence beneath the legal summary: "Let her take everything she thinks is mine." Evelyn turned to the attached liability schedule. Her face changed as she read the secured loan federal tax exposure, pending civil claim, and administrative duties attached to the estate interest Gloria demanded. "Mara, she does not understand what she is asking for," Evelyn said. I closed the file and placed Nathan's West Point ring on top of it. "That is why we must let her ask for it in writing." Evelyn read the liability schedule 3 times before she sat down. The afternoon light had faded from Nathan's study, but neither of us turned on a lamp. She kept one finger beneath the total secured debt and said, "Knowing this does not make the plan safe. Gloria can still challenge the trust, the reorganization, and Nathan's capacity." "I know. She may force years of litigation." "I know that too." Evelyn looked at the West Point ring resting on Nathan's memorandum. "Then tell me what you want me to do." "Make sure every document is authentic. After that, let Gloria describe exactly what she wants under oath." The next morning, Calvin Ross arrived carrying 2 banker boxes and the same worn briefcase he had used since Nathan founded the company. Calvin had served with my husband in the Army before becoming his accountant. He trusted numbers because they did not salute, rank, flatter grief, or change their story when a room became uncomfortable. He spread the records across our dining table. The Survivor Trust had been established 3 years earlier while Nathan remained active in the business, and months before, his cancer returned. Our house, several protected accounts, and my right to remain there were documented outside the probate estate. The operating company had also been reorganized before Nathan became ill. Its vehicles, employees, medical transport contracts, warehouse leases, and revenue belonged to Whitlock Service Cooperative. Veteran employees held protected ownership shares while I served as oversight trustee. The old Whitlock corporate entity still existed, but it no longer carried the functioning business. It held the family property near Versailles, the secured loan disputed tax obligations, and the civil claim connected to Gloria's nephew. Gloria had demanded the Whitlock business because she recognized the name. She had never asked which legal entity paid the employees, owned the trucks, or held the contracts. Calvin tapped the liability summary. Nathan did not leave traps. He left consequences in the places she was already reaching. Evelyn asked whether Nathan had intentionally moved valuable assets to defeat his mother's inheritance rights. Calvin shook his head. The restructuring protected employees and creditors after the failed family project threatened the original company. Board minutes, valuations, tax filings, and independent counsel opinions documented every step. Nathan had paid fair value when assets moved between entities. Nothing had been hidden after his diagnosis. Gloria's expected claim had influenced his personal estate plan, but it had not created the business reorganization. Calvin also produced medical evaluations and recorded estate conferences. Nathan had answered questions about his assets, family medication, and intentions without assistance. 2 physicians confirmed his capacity. A separate attorney had advised him while I waited outside the room. Evelyn finally exhaled. "The structure is stronger than I expected." "Nathan expected," Gloria Calvin replied. We moved the files into Nathan's old office. For the first time since the funeral, I poured coffee into his chipped enamel mug. Calvin accepted it without mentioning that I had prepared only 1 cup. He told me about a young veteran Nathan hired after the man arrived late for his first week of work. The employee's truck had broken down and he expected to be fired. Nathan spent the evening helping him repair it in the warehouse parking lot. "He told me a man who keeps trying deserves tools before judgment," Calvin said. I ran my thumb over the chip rim. Nathan had not built the company so a name could remain above a door. He built it so people who had served would still have a door to walk through. 2 days later, Gloria filed an expanded petition. She no longer requested only Nathan's personal accounts. She claimed the family residence, every Whitlock business interest, all company records, and authority to administer the estate herself. Her attorney argued that I had isolated Nathan during his illness and influenced him to transfer property. Gloria submitted statements from relatives who had visited only during holidays, but claimed Nathan appeared confused near the end. Evelyn prepared objections to each allegation. I authorized her to defend the survivor trust, the cooperative, in Nathan's capacity. However, I instructed her not to oppose Gloria's request to receive the probate interest she specifically named. "You are drawing a line that nobody else will notice," Evelyn said. "The judge will notice." Gloria interpreted our limited response as fear. She began telling relatives that I had discovered Nathan never intended to leave me the business. One cousin called and advised me to accept a modest settlement before Gloria removed me from the house. I thanked him and ended the conversation. At the first settlement conference, Gloria wore Nathan's childhood family pin on her coat. She demanded that I vacate the house within 30 days, surrender company keys, and acknowledge that the Whitlock legacy belonged to blood relatives. Evelyn reminded her attorney that the residence in Gloria's petition was not the house where I lived. Gloria waved the distinction away. "My son owned property. I want all of it." Her attorney asked whether that included every probate business interest, secured asset, administrative right, and attached obligation. Gloria looked at me before answering. "Everything." Evelyn wrote down the word. I placed the brass workshop key on the conference table, then returned it to my bag. Gloria watched the motion and smiled, believing I had shown her the symbol of something she would soon own. Afterward, Evelyn stopped me in the courthouse hallway. "We can't explain the debt now. She may withdraw and save everyone months of work. If we explain too soon, she will withdraw too soon. She is Nathan's mother. That is why he gave her years to understand responsibility. She chose ownership instead." The estate review continued for 6 weeks. Each time Gloria had an opportunity to narrow her claim, she enlarged it. She requested authority over the old company accounts, the Versailles property unresolved receivables, and Nathan's guarantees. Her attorney repeatedly used language broad enough to capture liabilities as well as assets. Evelyn sent written questions asking whether Gloria intended to accept the estate interests, subject to all valid liens claims and administrative duties. Gloria signed yes. She believed every question was an attempt to frighten her away from wealth. The civil claim became more serious during that period. The failed real estate project had left environmental repair costs on part of the family property. The secured lender also issued a formal demand against the old corporate entity. Federal tax examiners requested missing records from years when Gloria's nephew managed the project. None of those developments touched the survivor trust or operating cooperative. They remained attached to the portion Gloria demanded. I did not celebrate. Every new figure represented a mistake Nathan had spent years trying to contain. He had carried the burden quietly because Gloria refused to admit her pressure helped create it. One evening, I opened the olive notebook and found a page I had overlooked. Nathan had written, "Mara will want to warn her. Remind Mara that warning is not the same as being heard." I closed the notebook and allowed myself to miss him without solving anything for anyone. The week before court, Gloria sent a proposed public statement. It claimed I had voluntarily returned the company and family home to their rightful lineage. She wanted my signature beneath it. I declined the statement, but confirmed that I would not contest her petition for the probate interest listed in the court filing. Gloria announced to the family that I had surrendered. What happened next is why silence should not always be mistaken for defeat. Some arguments cannot be won by speaking louder. They must be allowed to reach the page where consequences become impossible to rename. On the morning of the hearing, I wore a simple black suit and carried Nathan's folded flag in a protective case. His West Point ring rested in my pocket. Evelyn brought the estate documents while Calvin waited outside with the accounting records. Before we entered, Evelyn gave me one final opportunity to change our position. Once you sign the renunciation, Gloria becomes the leading petitioner for administration of those interests. That is what she requested. She still thinks she is receiving the operating company. She was given every schedule. Evelyn studied my face. Nathan trusted you with an unbearable amount of patience. He knew I would rather rescue her than watch her fall. And now I understand that rescuing her would only move the weight back onto people who did not create it. Inside the courtroom, Gloria sat beside her attorney with Nathan's family pin still attached to her coat. Several relatives filled the rear benches. When Judge Simon Hale entered, everyone rose. The hearing began with challenges to Nathan's capacity. Evelyn presented the physician evaluations, independent legal notes, and video from the signing conference. Judge Hale found no evidence that Nathan lacked understanding or acted under my control. Gloria's claim against the survivor trust weakened immediately. The trust had been validly funded years earlier. The house where I lived did not belong to the probate estate. The operating cooperative was governed by separate agreements and employee ownership protections. Gloria looked confused, but her attorney reminded the court that she still sought Nathan's remaining estate interests. Judge Hale asked whether she wished to narrow that request after reviewing the filed schedules. She whispered with her attorney, then looked directly at me. "No, Your Honor. My son's widow has agreed not to fight me. I want everything he left in the estate." Evelyn placed the renunciation documents before me. I signed that I would not seek appointment as administrator and would not oppose Gloria's petition for the listed probate interests. I did not renounce the survivor trust protected accounts or cooperative because none belonged to that estate. Whispers moved through the benches behind us. Someone said I had lost my mind. I signed the final page calmly and returned the pen. Gloria smiled as though the courtroom had just restored a kingdom to her. She placed one hand over Nathan's family pin and leaned back in her chair. Judge Hale reviewed every signature. He turned to the liability schedules, read the secured claims, and examined the administrative acceptance language Gloria had signed. Then he closed the file. "Before I approve your petition, Mrs. Whitlock, I have one question." Gloria lifted her chin. Judge Hale folded his hands. "Who do you believe becomes personally responsible for administering the estate's secured debts once the widow renounces, and you insist on taking everything?" Gloria's expression changed before her attorney could answer. She looked from Judge Hale to the liability schedule as though the numbers had appeared after she signed. "The estate pays its own debts," she said. "I am asking for the assets." Judge Hale opened the file again. "You are asking to administer and receive the listed estate interests subject to their recorded liens, claims, and contractual obligations. The operating cooperative and the survivor trust are not among them. Did your attorney explain that distinction?" Gloria turned toward him. He lowered his voice, but the courtroom was quiet enough for me to hear. "We discussed the schedules, Mrs. Whitlock. You told me Nathan owned a company." "He owned interest in the older entity. The company with the trucks. Number. The medical contracts. Number. The warehouse. Number." Each answer removed another piece of the victory she had announced to our family. Judge Hale asked the clerk to display the estate inventory. The first item was the Whitlock family property near Versailles. Its appraised value looked impressive until the clerk read the mortgage balance repair estimate and environmental claim attached to part of the land. The second item was Nathan's remaining interest in the original Whitlock Corporation. Calvin's records showed that the corporation no longer employed workers-owned vehicles or received operating revenue. It carried the secured business loan and unresolved obligations from the failed project Gloria had once urged Nathan to support. The third section listed the federal tax review, administrative expenses, and pending civil claim. Judge Hale read each entry without raising his voice. Gloria's attorney repeatedly adjusted the papers in front of him, but no new asset appeared beneath them. Gloria pointed toward me. She knew all of this. Yes, Judge Hale said. The schedules were filed and served on your counsel. Mrs. Whitlock's attorney also asked 3 times whether you wished to narrow your petition. Gloria said I had tricked her by refusing to fight. Judge Hale looked at her for several seconds. A person does not deceive you merely by declining to prevent you from reading documents placed before you. No one in the rear benches whispered after that. Gloria insisted that Nathan had created the structure while ill to keep his mother from inheriting. Evelyn presented the dates again. The survivor trust had been funded 3 years before his final diagnosis. The operating cooperative had been formed after independent valuations and creditor approval. Nathan had transferred assets for documented value and protected veteran employees through signed ownership agreements. 2 physicians confirmed that Nathan understood every part of his estate. Video from the signing conference showed him identifying the trust company's debts and beneficiaries without help. I had waited outside during the legal advice and entered only after the documents were complete. Judge Hale asked Calvin to explain why the older corporation still existed. Calvin stood beside the witness table. Colonel Whitlock wanted every valid creditor paid from the entity that created the obligation. He would not move debt onto employees or his wife merely to make the books look cleaner. Gloria interrupted. That debt came from Nathan's decisions. Calvin opened an email chain from years earlier. Gloria had urged Nathan to preserve the guarantee for her nephew's development project. She wrote that refusing would humiliate the family and prove that marriage had made him disloyal to his own blood. Nathan's replies warned that the project was underfunded and that the guarantee could threaten the original company. Gloria continued pressing until he agreed to a limited extension. Her nephew defaulted 6 months later. Judge Hale asked whether she remembered the messages. Gloria's lips moved, but no answer came. I did not enjoy watching her shrink into her chair. She was Nathan's mother, and grief had already taken her son. But grief did not create the demand she brought into court. It only gave her a room in which she believed nobody would challenge it. Her attorney requested a recess. When court resumed, he announced that Gloria wished to withdraw her demand for appointment as a state administrator and reconsider several claims. Judge Hale allowed the withdrawal, but warned that she could not continue describing the protected trust or employee cooperative as property wrongfully taken from the probate estate. Any future challenge would require evidence beyond resentment and family tradition. The court upheld the survivor trust, Nathan's business restructuring, and the Independent Veteran Fund. A neutral administrator was appointed to resolve the old corporation, negotiate with creditors, and supervise the sale or repair of the Versailles property. Gloria received several personal items Nathan had specifically named for her, including family photographs, his childhood Bible, and letters from his years at West Point. She did not receive control of Whitlock Service Cooperative or the house where I lived. When Judge Hale adjourned, Gloria remained seated. The family pin on her coat no longer looked like a medal. It looked like an object she had mistaken for authority. Evelyn touched my shoulder. You knew the question would come. Nathan knew. I took his West Point ring from my pocket and closed my fingers around it. I did not feel that I had won. I felt that I had finally reached the end of the instructions he left me. The consequences traveled through the family more slowly than courtroom news usually does. Relatives who had called me a thief learned that I had protected Nathan's employees, while Gloria fought for an empty corporate name. Several apologized. Others simply stopped calling. The old corporation entered supervised resolution. Creditors received accurate records, and the Versailles property was sold after its environmental obligations were addressed. There was no hidden fortune beneath the debt. Gloria had nearly spent months fighting to control a burden that Nathan had already spent years containing. She came to my house 6 weeks later. I met her on the porch because she no longer had a key. She accused Nathan of setting a trap for his own mother. Nathan did not trap you, I said. He stopped letting you hand your consequences to someone else. Gloria looked through the window toward the folded flag in its wooden case. Her voice weakened when she asked whether I hated her. I do not want to carry hatred, I said, but forgiveness does not return authority. I told her she could receive copies of Nathan's photographs and visit the memorial events as his mother. She could not enter company offices without an appointment, direct employees, contact financial institutions, or speak publicly as though she represented Nathan's business. If she wanted a relationship with me, it would have to exist without control. She agreed because the court had left her no other path. Trust did not return that afternoon, and I did not pretend it had. Peace built on pretending is only another delayed argument. 18 months later, Whitlock Service Cooperative employed 43 veterans and military spouses. We converted Nathan's first workshop into a training center for people moving from military logistics into civilian transportation work. The brass key hung in a frame near the entrance. Beneath it was a small plaque with Nathan's favorite rule: account for every person before you move the convoy. His chipped enamel mug remained on my desk. I kept his West Point ring in the top drawer and brought it out only on the anniversary of his retirement. The folded flag stayed at home where morning light reached the glass. Gloria attended the workshop dedication. She sat in the second row, said nothing during the ceremony, and left before the reception. That was not reconciliation, but it was the first time she had entered Nathan's legacy without trying to own it. Some people demand everything because they never learned that ownership and responsibility arrive together. Nathan protected me, not by leaving me more, but by refusing to let greed transfer its cost onto innocent people. Silence looks like surrender to those who understand only noise. The judge did not rescue me. He asked the question Gloria should have asked before demanding everything. If someone is pressuring you to surrender during grief, read every page before you answer. And when another person insists on taking everything, look carefully at what travels with the word everything. Have you ever watched greed defeat itself once the full truth reached the record? Share what that moment taught you. I would be honored if you pass this story to someone who needs to remember that calm is not weakness, and join me again for another story of courage, justice, and healing.